Testing 1, 2, 3. Bennett, can you hear me?
Evening, everybody. We're glad to have you. We're glad we don't want to stay any later than we have to, but we're going to get started here. We're going to call the Government Oversight Committee to order, room 307, and starting here at 6:30. Tim, could you open us in prayer, if you will, and lay your microphone number 7?
And if you'll join me in prayer.
Okay.
Well, we'll go with it anyway.
Wait till they get down. All right.
I'm about just throwing amen and be done.
Yeah, you can pray for those two that came in. That's what you're going to do. All right. Tim, if you will, pray for us, please, sir.
Yeah, we definitely pray for Senator Robertson. But thank you, Lord, for giving us this day and allowing us to have a productive day here and allow us to do the business of the people of this state properly and have knowledge on the bills that we look at. As always, we are thankful for the ultimate sacrifice that your Son, Jesus Christ, gave to us upon the cross, forgiving us for our sins and saving this world instead of condemning it. In Christ's name we pray. Amen.
Amen. Thank you for that. I appreciate that. Tonight we've got two bills before us, SB 117 with Senator Rick Williams. We've got also Senate Bill 170, Senator Kim Jackson, and I'm going to ask Senator Williams if he will come forth to present to us Senate Bill 117, that's LC 461022. You want to do that from here, or would you like to do it down on the front?
I can do it from here if it's all right with you, Mr. Chairman.
I will give you the floor and number 11.
Thank you very much. This is LC 461022. This bill was, and this idea was brought to me by an employee of a county government. She actually worked for one of the county agencies. This agency started meeting outside of advertised times. They were not advertising the meetings. And so she went to the county attorney and told him and told this committee that they were actually meeting and they were breaking the Sunshine Law. So anyway, she brought it to their attention and they shrugged her and continued to do so. And she went to the county commissioners and the county attorney and told them that, look, they're breaking the Sunshine Law. They're doing those meetings illegal. And so the county agency retaliated against her, actually moved her desk in the hallway out of the office. And one of the board members actually walked by her and purposely bumped into her. And a deputy happened to see it, and that board member was actually arrested and charged with assault. And what this does, this gives a whistleblower room that if they're retaliated against, they can seek relief in court. This young lady was put through a lot of mental duress. And so she asked me to bring this, and I'm doing it to protect all whistleblowers. And I think this is something we're going to be having to deal with. Thank you.
Okie doke.
Be glad to answer any questions.
Any questions on the bill? No questions on the bill. Okay. What late arrival question coming? 13, 14? Okie doke.
Thank
Yes,
you,
sir,
Chairman.
Senator.
Chairman Harbin. Thank you, Senator Williams. My question is, I was just reading, I should say rereading, but I'm going to be perfectly honest. I'm just getting to it now. It's been a long day. Can you just tell me what the current procedure for noncompliance is with the for example, the lines that are already in law, right, on 46 through 52 through 59, et cetera, about non-retaliation. Is there a penalty of any sort right now, or no?
Apparently
Civil
not.
action.
Apparently not. Well, it just says no public employer shall retaliate against a public employee for objecting to or refusing to participate in any activity, policy, or practice of the public employer that the public employee. Of course, you're a lawyer. You can read this stuff, and you got it all memorized. What this is doing is just adding
Action.
line 81 and 82. Any agent of a public employer who violates subsection D of this code section shall be guilty of a misdemeanor. So it's not making them guilty of a felony, it's just making them guilty of a misdemeanor, so that this person that's actually been retaliated against has a way to seek relief.
Thank you so much, Senator. And yes, I was able to scan it further, and I do see that right now, 71 through 80, people can get like an injunction to be reinstated, et cetera, and the like, but not via the action against the agent. So
Yes,
thank
ma'am.
you so much, Senator. Appreciate it.
Thank you.
Thank you. Senator Roberts.
Yes, sir. So my understanding reading this, the definition on 24 to 28, this covers not only state employees, but it covers local government employees also.
Yes, sir.
So it does not cover, say, school boards?
I would think that it did.
Well, I see board on here, so are we talking about elected officials also?
Yes, sir. I would assume so. I'm not an attorney, so it may be a question for ledge counsel.
We want to get.
It is.
Do you want us to get ledge counsel?
Yeah, I just want the
ledge
opinion.
counsel?
I think it would.
Is he looking? Page 2, Mike 1. Mike 1, you're on.
Okay, perfect.
Okey-doke, thank you.
Is the question just a clarification as to whether board would include?
Board would include elected boards, school board.
So we typically would add a little more language to clarify that, but it could. It could.
I have a question too while you're there.
Yeah.
Oops.
Also, if I might, would this cover a student at a university? Say a student at a university were to have a professor do something that was out of the way, and they were a whistleblower against that professor. Would this also cover that?
I don't think it necessarily would cover that. I think typically whenever we're dealing with universities, because we have like the special rules with the Board of Regents and that sort of thing, we are a little bit more specific when we're trying to address universities. So I would add further clarity to the extent you are looking to address.
Could that amendment be added to this bill?
Yeah.
Okay, good.
You guys wanted to do that?
Good.
I could do a follow-up.
Yep, Tiana.
I do want to point out to the Arthur and to those on the committee that while the line 71 through 80 that was mentioned earlier lists things that are opportunities for the offended whistleblower, that it says any action brought pursuant to this subsection, the court may. And then if you jump down to F, it says a court may award reasonable attorney's fees, court costs, and expenses to the prevailing. And when we get down into the author's amendment, I think the correct word is used where it says any agent of a public employer who violates subsection D of this code section shall be guilty of a misdemeanor. So just want to make sure it's clear that while it looks like there's a long list of opportunities for the offended to be made as whole as possible, that is a may.
So you're looking at, you're looking at line 79?
No, sir, line 71 through
71.
79.
Okay.
Where it says may, but then So the teeth in here, I think, is added by the author of the bill, which I think is an extremely positive addition to this legislation.
Okay, very good. Senator Moore.
Mr. Chairman, upon a due pass motion, I'd just like to offer an amendment to add in line 26, university employee.
Okay, let's ask Ledge Council again. You are on. Are you following with us on?
Yes.
Can we insert in that section?
Okay. Sorry.
Can we insert, as I understand, what you want to do is you want to insert within 24, am I correct, 26, you want university, did you say, Senator Roberts, Senator Moore?
Yes, sir. I'd just like to add university employee.
University,
I mean, we would typically, it would be the university system of Georgia, so maybe an employee of the university system of Georgia, and then there's also the technical college, I forget what the exact name is. TCSG, the technical college system of Georgia, so we could probably add something for those, but I would mention that there's probably, and I'm just going off the top of my head, there's probably a concern here just because the whole point of the Board of Regents and the university system is that they are separate under the Constitution. So we do run into conflict sometimes when we're trying to bind them to things like these because they technically, arguably have a separate power.
is my understanding, and I'm not a lawyer either, maybe we have some other lawyers here, is that between the university and the state, the university, basically we fund it, but they have the right to rule themselves pretty much as far as that, and I think that's what you're talking about.
Yeah, under the Constitution.
Under the Constitution.
Yeah, they are a separate entity.
Separate. Do we have any concurrence on that? That's your opinion as far as that point.
Yeah, I'm just going off the top of my head right now, but yes, that's typically
Okay.
what we would say
Mr.
there.
Chairman.
Okay, 10. Is that Senator?
I really appreciate it a lot. And to Chairman Moore's point, I want to make sure where I read it says public employer means the executive, judicial, or legislative branch of the state, any other department, board, bureau, commission, authority, or other agency of the state which employs or appoints a public employee or public employees, or any local or regional government entity that receives any funds from the state of Georgia or any state agency. Is there any possibility, reading that language like that, understanding the separation of the Board of Regents, that that could be interpreted to include them?
That's a little difficult for me to answer. Typically, I would have to kind of see how this plays with the other code sections and how we've typically defined it throughout the code. It could potentially be read that way, but there's no certainty without clarifying it, because throughout our code we do tend to clarify sometimes, that if we are meaning to, to oversee those entities, we do include it specifically. So to the extent we're not doing that here, that creates some kind of confusion, if that makes sense.
It does. I just read this almost as a catch-all statement.
Yes, it typically would be. It's just that the university system, the Board of Regents has this special constitutional, provision that pretty much separates it, and it does create the potential for it to be subject to challenge that, it's not included within this provision on that ground.
Okay.
Mr. Chairman, if that's the case, let this committee, let it be the legislative intent of this piece of legislation. I believe that as we read it, we believe it includes the university systems.
Okay. I think we need to get clarity on that if we could. Mr. Beard, yes, sir.
This one's going back to legislative council too. So if I'm reading this correctly, under
Okay.
45.1.4, we're making one change on one word on line 20. Then we're adding a criminal offense in 8182. So if I'm reading line 79 correctly, there is a right of action to a person already if the whistleblower is retaliated against, correct? So there is a right of action already for a whistleblower.
Oh, you're saying if
So
there's yes, there is an existing right of action through 67 through
okay.
through 80. That would be outlining. Typically, it would be underlined if it's new
Okay.
language. So that would mean it's existing to me.
And I skipped right over those two lines while I was
Oh,
going
no,
through this
you're
bill, so
okay.
I appreciate that. So basically, we're adding a criminal charge. now.
Yes, it appears.
Yeah.
I didn't draft it personally, but my
Okay.
understanding is right here we're adding a criminal charge.
Thank you. And again, it's late in the night, and I just went right past those two lines. So thank you for pointing those out for me.
All right. With Ledge Council, would it be where we could get something just for the committee
Yep.
to know an opinion on
Yep.
the issue, whether it would include our universities as well?
Yes, I'm happy to circle back on that one for you guys.
Okay. I think
I'll touch base with Michael. I know you're familiar
Right,
with Michael.
right.
He's our expert on the education
on that.
and that sort of thing.
Okay, if you
so-
could get that cleared up, I
Yes.
think that would help us. And possibly what I'm thinking is that when, either on the floor or in rules, that we could make that change on floor or in rules as far as that. Senator Roberts.
Mr. Chairman, if the time is right, a motion do pass.
Time. Do we have a second from Senator Moore? Any further discussions on this? No? Okay. We're in discussion.
I would, on line 71, I would offer an amendment to strike the word may and replace it with the word shall.
Okay.
On line 79, would strike the word may, replace it with the word shall.
Okay.
That would be my amendment, Mr. Chair. Yeah,
Yep,
that's-
come-
yeah,
coming
we'll
up-
wait for
coming-
a second.
Are you done?
I'll second that amendment.
Okay. So we have an amendment seconded, and now we're going to go to discussion. To Senator Parrott. There we go.
Thank you. Yeah, 14, you got it right,
Gotcha.
Chairman Harmon. Whip Robertson, I don't at all disagree with the intent, but I don't think we can actually do that, because then it would say if anyone brought an action, the court has to do that, which we can't have.
And that was going to be my question to you. When I did that, I think, would I have to preface that with, upon a finding that the court shall?
Well, I guess what I would say, I mean, that might be an option, although I would certainly want, like, counsel to write it. I guess my question to you would be, is the intent that you want to make sure A through E and F all, 2A through E plus F all happen? Like, you're trying to make sure they all happen?
Right, I'm trying to make sure if it's determined that the action, and this here addresses that the action did occur, that the harmed employee would be able to receive, yes, ma'am.
Well, I would say that you probably, it would make sense to say upon a finding, except you probably still want some discretion due to the fact pattern on the ground, only because, like B and C, for example, the particular employee might not actually want the position back.
Well, and let's see, I'm sorry, let me. And I think if and in that case, yes, ma'am, I think if the court ordered, the shall would be that the return to the job would be one of the options, would have to be made. And then it would, of course, be up to the employee whether or not they wanted to go back and accept it. But it would require that the employer offer them the job back with the compensation of lost wages benefits and the other. And then I think 79 would be an even stronger point to help these employees feel more emboldened to make these complaints when they know that reasonable attorney's fees would also be required to be reimbursed.
Well, I totally
And I-
understand and respect where you're going with this. I
Yes,
do
ma'am.
have some concern that we're upsetting like an apple cart that the author didn't bring us, and that we don't really know like how it would actually play out in real time. And I would hate to. I just think the committee should think: do we want to go down that path without getting more information on whether judges all of a sudden come out and oppose the senator's bill
Right.
and all this other stuff,
And-
right?
and look at-
Before maybe.
Yes, ma'am. And looking on line 67, it says a public employee who has been the object of retaliation in violation of this code section may institute a civil action in Superior Court for relief as set forth in paragraph 2 of this subsection within 1 year after discovering in any action brought pursuant to this subsection, the court, and in there would be that. So I could see, I see your concern, I do.
I mean, you could say, Senator, something like, upon a finding of a violation, the court shall order any or all, so that you know that the person gets something. But without sort of insisting on things that might not fit a fact pattern, because then that could upset the whole
Right.
scheme,
And that
right?
was, and that was where we started out when I
Yeah.
said, where we put some language in there that would show that the court did find in the affirmative for the individual that
That
was.
there need to be some redress.
Yes,
And you
ma'am.
feel like right now, it's just wide open that there might not be any redress.
Yes, ma'am,
So I
especially.
think we could handle that another way.
Especially
Yeah.
in these cases where the employee may end up being in a courtroom where somehow the offending party has some sort of influence or
Yeah.
some relationship that could be
fair.
counterproductive for the offended party.
Right, so we want to make sure that the judicial system isn't kowtowing to someone powerful.
Yes,
or
ma'am.
not kowtowing, that's the wrong term, but you know what I
Right,
mean.
yes, ma'am.
So maybe the other language about shall order one or more of,
Right, yes,
Let me
ma'am.
ask a
upon a finding of a violation.
Yes, ma'am.
Okay.
Let me
Okay.
ask a question.
One, come into the author.
If you leave the word may on 71 and just change the word may to shall on 79, because it says a court shall award reasonable attorney fees, court costs, and expenses to a prevailing public. I mean,
That's an
that
option.
means they've won, then the court shall do it. So if you leave the may up there and just change the may to shall there, I think would accomplish it.
Ledge counsel, can we get you back in here?
I can help. What we could just do is we could say, we could just say all shall order any and all of the following relief as applicable.
Now, on line 71, leave the word may. The court may order any or all of the following relief. And then when you get down to line 79, a court shall award reasonable attorney fees, court costs, and expenses to a prevailing public employee. That means that they've won, they've proved their case, and so the judge could then say, okay, I think it covers it, I think it captures it, and I'm no attorney, but I did sleep in the Holiday Inn Express last night.
And he's buried a lot of people.
I see
Okay.
where you're going with that, Mr. Chairman, yeah.
Does
Okay.
that sound right, though?
I mean, without doing a deep dive, seems on its face like it's a reasonable option.
So we've got an amendment
Well, we have,
No,
right.
Yeah.
in discussion.
Right now, I think
I
we-
would,
okay.
go ahead, I'm sorry.
Well, no, I'm just wondering, Mr. Chairman, do we have two amendments right now that have been seconded?
We've
Or
just got one
one?
amendment right now,
Okay.
which is the two mays to shall, from that standpoint.
And I would say, if it's proper, I would yield to the wishes of the author of the legislation, if he feels more comfortable with the language that he's using. So if my amendment could be written in the way it was stated by the author, I would be comfortable with that unless there's an objection on the committee.
Okay.
Yeah.
We're in agreement on that. So, Ledge Council, can you read that back, what you're going to do to us?
I was gonna ask if he could go ahead and repeat that for
Hold
me.
on, okay. So we gotta get,
Okay. On his amendment,
Okay.
the only thing he's changing is line 79, a court shall.
Okay. Yep.
So that's the only one word changing that may to a shall.
Yep. I have that. Okay.
okay. Okay.
Got it.
So the amendment has been, what was originally, so do we have to, I think we've got one with the two shalls.
No,
Did- Oh, you yielded, okay, great. Okay, fantastic. Okay. And we got,
Second on it, so
we-
we're in the mode of voting on the amendment.
we're, unless there's further discussion, we are voting on the amendment to change may to shall.
Got it.
If you would, all in favor, raise your. In line 79, correct. From may to shall, all hands up. And 1, 2, 3, 4, 5.
oh, can I vote for my bill?
Yes, you can vote for your bill, okay. Okay,
My amendment?
it's unanimous, okay. Okay. So now that we have an amended bill, and this will be Senate Bill 117, LC 481022, as amended. Do we have a motion on the amended bill? Do pass? Do pass as amended. Do pass as amended. We've had by committee substitute. We've got those. And all in favor, raise your right hand. All right. Okay. Thank you. Thank you. All right. That's well done. And doing that, we've got one more. Senator Kim Jackson, do you want to go down front or you want to stay where you are? You'll stay where you are. Okay, so I'm going to give you number 13, and you can share with us SB 170, LC 560330S.
That's right. Thank you, Mr. Chairman, and thank you all for staying at this late hour to consider this bill. This bill comes as a result of a study committee that we heard back in 2022 on issues around homelessness. And what the bill does, very simply, is it creates an interagency council. So right now we have many agencies across the state that interface with people who are experiencing homelessness in any myriad of ways. So DBHDD has some interface with people who are experiencing homelessness. Department of Corrections has a different experience. The DCA has another experience. And oftentimes, as a consequence of these agencies being quite siloed, the left hand doesn't know what the right hand is doing. And so one of the things that we discovered in our study committee was how clear and true that was. And that particularly for anyone who was on the ground who was experiencing homelessness, they felt that impact the most because they were getting services from one department but not the other, or the other department was duplicating services, and it was just messy. So one of the things that we came up with, a recommendation from the study committee, was to create an interagency council where they would get together on a quarterly basis at least to coordinate and to talk about the different services that they're able to provide and to really work together. We heard this bill last year. It came out of this committee unanimously last year. And what I will say that we learned in the process of doing this bill is that there were agencies that we didn't even know interfaced with people who are experiencing homelessness who called us and asked to be added to the bill. Because they were very clear, like, hey, I mean, the Department of Community Supervision was a really good example of that. You know, they're like, we want to be a part of this conversation because we know that there are services out there that we're just not coordinating. And so we think this is a really valuable move, a real step towards helping to create a real continuum of care. Pardon the use of that language for those of you who are experienced with it, but a coordinated care across the state, across all agencies around this issue. It doesn't cost any money. And in this bill, we put the authority for the gathering with the Department of Community Affairs to gather, and each member will be a member for 3 years. The last thing I'll add is that because this is about people experiencing homelessness, we do ask that the governor, who would appoint all members, would include 3 people on the committee who have experienced homelessness, along with 3 people who are service providers, current service providers that are not related to an agency as well, to the council, to kind of round it out and make sure that it's a full representation of the whole group.
All right, thank you. Questions? Anybody have questions? Number 14, Senator.
Thank you so much, Chairman Harbin. Thank you, Senator. My question is, you mentioned not that on line 17 about line 54, 3 members representing service providers who should not already be doing the work in one of the agencies. Is that clear elsewhere in the bill that you want them to be separate from the agencies, or does that need to be clarified?
I don't think it needs to be clarified.
Okay.
But yeah, that's the intent.
Okay,
Thank you.
13, let's see, we got 13.
I'm 13.
Oh, okay, did you want to say something?
No, sir.
Okay, number 3, yes, Dr. K.
Thank you for bringing the bill to us. I just had a question about, I've served on a number of these commissions and things, and they kind of take on a life of their own and go on forever, and don't, because there's no set endpoint. Frequently, there's not a final report that comes out with, a list of very concrete things that need to be done. So when we created the commission that Kaylee Noggle is chairing on Medicaid, for example, we gave that a finite period of time and then requested a report. And so it has a sunset, is what I'm trying to say. Had you considered that?
Yeah, I will say, I'm open to the will of the committee on that. I think because this is an ongoing issue that we don't expect to be resolved in 3 years or 5 years, and because these are all interagency, these are agencies that are going to continue to exist and continue to work and interface with people who are experiencing homelessness, we didn't see that as having a definitive end. There is a reporting that is required here. It's an annual report that is required, and they are tasked with coming up with their continued goals. But certainly I will, if the will of the committee is to provide a sunset date, we are certainly amenable to that. But again, because of the ongoing nature and the complexity of so many agencies working with these folks, we did not see this we don't see this as being set up like a study committee or a task force. We see this as important work that should be ongoing amongst the agencies.
Okay.
Mr. Chair,
Follow up, yes.
Yeah, so I know what you're saying. We've created for example, the Behavioral Health Commission. We put a sunset on it,
right.
and then their work wasn't completed, and so they asked to extend their sunset, and we've done that. There's another bill to extend it again for, I guess, a 3rd time. So, you can always extend it, but you would hope, like we hope with a lot of things, that you're going to at some point get a handle on it and put yourself out of business, if you know what I mean. So
I certainly know what you mean. I certainly have that hope. I will accept if you would like to offer an amendment to provide a sunset. I'm certainly amenable to the will of the committee.
thank
Okay.
you. Let me look at what my.
Who we got? 7. I think we got questions popping up. 7. Yes, sir. Senator Beard.
Like Senator Kirkpatrick said, especially after we just did a bill to eliminate a lot of these councils, and I would be supportive of a sunset as well, where it may give it even a better chance to get through with us looking at a sunset instead of something that just continues to go on, because that's what we end up sunsetting or getting rid of just a few days ago.
Mm-hmm.
So.
Carol. Okay, Senator Harrell.
That wasn't a question.
Yeah.
Isn't it true?
Yes, is it? Senator Harrell.
Yeah, I just wanted to get on this a little bit. I don't really see the need for a sunset for this because there's so many departments, and you're probably going to have leadership in those departments moving in and out, and it seems like there would be kind of a constant need to coordinate.
Okay. Senator Jackson, who's it? Merritt, Senator Merritt on the end. Okay.
Thank you, Mr. Chairman. I just wanted to offer maybe not a sunset, but some time of review, and then after that review, decide if you're going to continue. I don't know how to say that in the bill, but that's what I would recommend.
Okay. And does anybody, I would ask this, does anybody know what's the normal period for a sunset? Is it 3 years, 5 years? Hold on, we've got,
Problem is, Mr. Chair, that it takes a while for these appointments to be made. And so you can't make it real short unless those appointments are, already in the works. So, I mean, it would need a sufficient amount of time for all the appointments to be made and then for them to do an annual report. So I would think that somewhere in the 2-year range might be the least amount of time that you could get some meaningful work. And you could do it either way. You could either sunset the thing or what you said, which is require an ongoing review by the General Assembly at some time certain.
okay. License, I'm gonna, let's see, I don't know who popped first. Number 12 is Senator Moore. You're the next one.
Thank you, Mr. Chairman. To the author, what do you anticipate coming out of this? I mean, do you anticipate a report coming back that tells the General Assembly they need to spend more money? Or do you anticipate something coming back that says, hey, we're actually duplicating our work in these different departments? And, I mean, do you anticipate savings? What do you anticipate?
Thank you for that question. My hope for this would be that the result of all of the agencies getting together, that they would do a comprehensive, it's written in the bill too, that they would do kind of a comprehensive survey of the services that each department is doing and see where there might be duplication, but also see where there are connections. So the Department of Community Supervision, which was a new overlay for me, is actually a really great example. They want to be in this conversation because they think that there's services available to their people that they're supervising that they're just not connected to and that they don't know exist, right? So, you can't, if you are struggling to help, say, find a housing voucher for someone who is in community supervision, DBHDD has housing vouchers, but so does DCA. And they're folks who work for the Department of Community Services. They're kind of just like us. Like, they don't necessarily know who the first person to go to is, but hopefully through these coordinated conversations, they would have a clear pathway, which would make people more efficient. Ultimately, it would save money because you don't have people running from place to place, but there is a clear pathway to receiving these services. And ultimately, I would hope get people back on their feet, right? The end goal of all of this is always to get people stabilized, right? So I think with these coordinations, we would help folks get stabilized. There's a piece around workforce development here that I think is really, really key. We want every single agency that interfaces with someone who's experiencing homelessness, we want them connected with that state force workforce development so that we can get folks stabilized. Does that help?
Yep. Let's go to, I'm going to go to Senator Randy Roberts because you were also on the study committee.
Yes, sir. I was on the study committee. I think to the points that everyone's making from Senator Kirkpatrick and Senator Bearden and Senator Moore and Senator Jackson, I think I've heard the word efficiency used a couple of times, and I think that is the goal. If you get all these individuals together to find where there's duplicity and inefficient functions within government and clear it up. But I think in order to push it in that direction, I think it does need to have a sunset date. I think it needs to be something reasonable. I appreciate Senator Kirkpatrick pointing out that the appointments are going to take a while, and I think maybe a 3-year sunset where we could come back and have the reports to show where the efficiency's done. And if there is productivity and if we do see more left to be done, then that can always be changed and continue marching forward.
Okay. We've got Senator Parrott.
Is it not true?
Yeah, is it not true? Senator Parrott.
Great. Thank you, Mr. Chairman. I also was, as a matter of fact, going to suggest 3 years because of the language on lines 55 and 56 where the council members are serving a period of 3 years. So unless we have to build in time for the appointment. But
Could you go one more year? That way you would assure.
4 years,
you'd have
maybe?
4
Well, I don't know.
years?
I'm wondering what
Okay.
Chairman Kirkpatrick
Senator
thinks.
Kirkpatrick.
I'm thinking 3 years after the appointments have been made.
After
Does
the
that make
appointments have
sense?
been made.
Because honestly, just having been down this road before with some of these commissions, if there's no end in sight, the work doesn't always move at a pace that is what we would be looking for. So that's the only reason I'm bringing it up.
Are we making the assumption that all these appointments are going to be done at the same time? Or will they be done at the same time so that we're coordinating that? That's a question I have for you.
Well, they're all done by the governor,
Governor should be done at one
so I
time.
would think they would be done at the same time.
Okay.
We may want to run it by their office at some point along the way. But if we wanted to do 3 years, start after the appointments are made,
Yep.
that would bring it to, I mean, let's just call it, what year is this?
It's 2025. So
25.
The end of,
So we're 2028.
yeah, the end of
If the
2028.
appointments are made this year.
they should be completed
should
by
be made
then.
They will be. Okay.
Because the law will be-
So we have talked this pretty much down. Let's see. Down, I'm doing that. It sounds like from the committee in discussion that we want to put a sunset of some kind on there. And we need a motion to put a motion, or put that sunset provision in place. And it looks like, I think, Dr.
Yeah,
Senator
I'm not,
Kirkpatrick.
as you know, I'm not a lawyer,
you are
so
a
I would
doctor.
have to see if Ledge Council could put it in the right legalese, but the amendment would be that the, are we calling it a commission? Interagency, what are we calling it?
It's a council.
Yeah,
Georgia.
that the interagency council
Interagency
would
council.
sunset December 31st of 2028.
Okay, we got a second. We got,
Second.
I have some recommended language if you want
Yes,
to hear that.
can you recommend this?
The council shall be abolished and this article shall stand repealed on December 31st, 2028.
Sounds good to me. I have an attorney on number 14.
Oh,
That's impaired. Okay.
when we finish this one, I have another small amendment to suggest.
Okay,
Mr. Chairman.
look it up. Look it up. So that's got, we have a
Did we have a motion on the
a motion, a second, to put as read with a 3-year amendment to sunset the bill on December 31st, 2028.
Yes, sir.
Okay. Any other discussion
Well, Chairman, we might need a motion to pass.
on the underlying?
on the original bill? Okay,
I'll make a motion to pass.
Motion to
on the-
pass.
On the bill.
on the bill. We got a second. Any discussion on the bill? Okay, Senator Moore?
Thank you, Mr. Chairman. Senator, I know you're very well intentioned on this piece of legislation and your heart is in the right place. I do, however, and I was talking to some folks the other day, to me, like Atlanta is starting to look just more and more like California when it comes to the homeless problem. And I think a lot of Californians are very frustrated with how the homeless has been taken care of and how the government has gotten involved, and it's only perpetuated the problem of homelessness, especially in and around Los Angeles. And it all kind of stemmed, I guess, originally from some commission. So I'll be voting no today. But just want to let you know I do appreciate.
That sounds consistent.
Okay.
I just want to speak in reference to the senator's point. Representing Atlanta, I just want to point out the mayor gave his State of the City address yesterday and pointed out that he has created hundreds of housing units to house the homeless here. So Atlanta is working on the housing problem. I just want to commend the mayor to not have that misconstrued as us hounding on them, trying to compare them to California. Thanks.
Yes, I have another small amendment. On 79, we should change the due date for the report detailing the council's activities, and obviously open to whatever the will of the committee is, but I was thinking December 2026 would make sense for the first report, and then it would be annually thereafter until, obviously, the sunset 2 years later. And I think the report annually is a good idea still, because that way it provides that sort of pressure to be getting some of the work done. Is my thinking on that, instead of just one at the end.
What I'm hearing is that you're you have not made an amendment yet, but are thinking about.
Oh, I'm sorry. I would like to make an amendment that we strike on line 79, October 1, 2025, and put in December 1, 2026.
And also,
Yes, on line 79. Because it wouldn't make sense to do one in this October with the new, right, the new idea of having the sunset. Yeah.
But also keep in mind in reference to when the appointment orders are done too. We have to factor in that time frame too.
Right, thank you, Senator. Yes, we were, I was considering that, and I think that's why that will be over a year. So it should be that they are in that position, I believe. But yes, thank you. I think, but the committee can do what it wants. That's the amendment I would like to offer.
If we were using 26, that really is going to probably give them about 18 months if the appointments get done, and then we're going annual thereafter from that standpoint. So your amendment would be as changing October 1st, 25 to December 1st, 26, and then this bill itself says they're annual thereafter. And so I think that's the amendment as I'm hearing it, right? Okay. So actually, we still have the original bill that we've got to deal with, and then we've got two amendments that we've got to deal with. And I'm going to try to walk through this
I think
as far
amendments first, though, Mr. Chairman, right?
Yeah, right. We got amendment number 1, which is a sunset provision for 3 years, and we use the date, am I correct, of 12, you read that 12?
December 31st, 2028 for the sunset.
28 for the
28.
sunset, but that,
That changes.
yeah, that's what it's,
It's going to change if Senator Parent says
26,
you saying 3 years, it put it at
29. So I think you, on the amendment, okay,
Oh, that's for the report.
for the report. Okay. Okay, this is getting fun. Okay. Just like the judiciary. Boy, that's dangerous. Wow.
It is a lot
Wow.
like judiciary.
Okay. Now, in the midst
Everyone is
of,
doing a great job.
okay. Before we, let's get the amendments out of the way, and then we do have one public, well, you wave. Okay. Our first, the First Amendment is going to be, okay. So our First Amendment is to deal with the sunset to be set at December 31st of 2028, correct?
Yes, sir.
Okay. Her language. Any more discussion? None. All in favor, raise your right hand. You raise your left hand, you're in trouble. Okay. Okay, y'all are latecomers, but that's good. Okay, you're worth waiting for. Okay. Looks like the amendment number 1 passed unanimously. The second is amendment changing on line 79 from October 1st, 2025 to December 1st, 2026. Is that the understanding? All right, any questions? None? Okay. So all in favor of amendment number 2, raise your right hand. Okay, looks unanimous. All right. Now we have a bill that has been amended. We have a public comment that's willing to waive his rights of speech, freedom of speech. We appreciate that, so we can go home. So, Bill, as a minute, do we need a motion on the final amended bill? As amended is what we've got, and all in favor of the what? Help. Do we have a second? I got an amendment.
Yeah, we did.
Okay. Okay.
Say no, as amended by committee substitute.
Okay, as amended by committee substitute. and we're going to discuss it some more, okay? Oh, come on now. You did good. Thank you. Thank you. Yes, sir.
To the senator, and I'm not sure who had made the comment. While we do appreciate the effort that is currently being made in Atlanta, and myself and Senator Jackson did serve on this committee with others. I think the worst thing we can do right now is get comfortable, especially with the news of a unsheltered homeless individual being killed in an attempt to clean up an encampment within the shadows of probably one of the most iconic houses of worship on the planet. So I think to Senator Moore's point, and the reality of it is San Francisco, or the book San Francisco, that I do have in my office if anybody cares to look. We should not get comfortable with some of the efforts being made, because we're a long way from addressing the issue related to finding places for individuals to go, and it is a problem, and it decreases the public safety, not only for the citizens that live in Atlanta, but for those individuals who find themselves in those circumstances. I came in the other day for a meeting. I got here at 4:45 for a 7 a.m. Subcommittee hearing, and amazingly, every time I stopped on the way here, I was approached by someone in the street. And so I think while we can claim small victories, we've got to find the correct solution, because right now it doesn't seem in sight.
Good comments. One more, Senator Kemp.
Mr. Chairman, I think we can all maybe agree if we can tap into that surplus and give some grants to our cities, we'd all be happy with that.
All right. Okay. Are y'all? We have a Senate bill, SB 170, LC 560-330S as amended, and we have a motion and a second, correct? All in favor? Your right hand. It looks unanimous. Nope. Okay. Okay. Peer pressure will do that to you, won't it? Okay.
Senator Moore's hand was up for a second.
Well, okay, Senator Moore. Okay, I'm sorry. Okay. All the other, Senator Williams? Okay, now you're, no's. You're the no. You're no. Okay, no, that's good. Okay, no. Very good. Okay. We are ready to close out if y'all are. I want to say something to y'all. We were concerned about having a quorum, and I think we got a quartet, from that standpoint, in that respect. To the committee members, we believed that food would help. There are some Chick-fil-A boxes back there. For those that can't, I don't know if there's enough for everybody, but I think there's 10 boxes, so first come, first serve. But I do want to say this. Thank you for being here, making the effort to be here. And I know it's late and all of that, but I think both the bills have benefit to the citizens of Georgia, and that's really what we're all about. So I thank y'all. Have a great evening. Look forward to seeing you early in the morning, probably. Yeah. See you later.